everyone. Welcome to Tech Policy Grind, a show by and about young professionals in the tech law and policy space. Today we're joined by Bijan Madhani, fellow Foundry member at the Internet Law and Policy Foundry, Senior Policy Counsel at CCIA, the Computer and Communications Industry Association, to talk about the General Data Protection Regulations, the new set of sweeping and far-reaching privacy regulations coming online in Europe this week on May 25th. The Europeans are coming. Should small businesses be concerned? Is the GDPR really Thanos? And if so, does that make the right to be forgotten the time stoned? We cover these crucial issues and more right here on Tech Policy Grind. So, sit back and enjoy our discussion with Bijan Madhani. Stay tuned next week for our special bonus coverage from our week at RightsCon, and we will talk to you next week.
All right, Bijan, welcome to the show.
Thanks for having me.
We really like to kick off the show by asking folks, what are you grinding for?
Apart from my morning frappuccino, I think it is, cashing checks, but also information policy writ large, sort of how the world's information is organized, how we handle that information, and who gets to see it is sort of what I live for thinking about on a daily basis. Fortunately, I get paid to do that. So, it's not a bad gig what I do at CCIA. I guess I should dive in a little bit to that.
Well, you're very young. You're Senior Policy Counsel at CCIA. That's,
titles
impressive.
are so flexible in the tech industry. I could have been, head evangelist for, information privacy, and no one would have blinked an eye. So
that's a good title too. Do you want to give a little bit of background to our listeners about CCIA? It's one of the older advocacy orgs in the country, and I know that, again, you're Senior Policy Counsel. So why don't you give us a little bit of background on that?
Sure. So CCIA is a trade association like many others in DC. We represent large and medium-sized internet companies and a few satellite providers and telcos, mobile telcos as well. And we have sort of an interesting history among the trade associations in that we were formed by sort of competitive internet or competitive technology and communications companies who are always challenging sort of incumbents in the space, usually through antitrust challenges. And so that's sort of been the general vein with which we operate in DC, which is to always ensure that, even though we have larger companies, smaller voices, the voices of their users, are always reflected in the policy positions we try to take. And so I think it lends us a little bit more flexibility as an association than others. And I think it lends us the ability to sort of think about issues more from a user rights perspective. And that can be challenging at times, but it also is I think it keeps us closer to sort of a nimble advocacy organization than it would sort of a rigid committee-based trade association.
So,
go ahead.
No, how did you learn all of this stuff? I think we first crossed paths, and I think you do a lot of surveillance style work. Mm-hmm. We're here today, obviously, to talk about the GDPR, which is a whole other realm of stuff. How do you, aside from sort of gathering information from all of your members, how do you pick up and learn all of these really complicated tech policy landscapes?
Twitter is a good place to start. Everyone there has at least 3 threads breaking something down that I can, turn to.
I love that you mentioned Twitter, because I don't think we've had a single show go by where we haven't mentioned Twitter. So
exactly.
Gonna keep on that Twitter train.
It's just a good way to keep track of developments as they happen. I also think that my job affords me some flexibility, and so there are some days where Congress is not in session and I don't have to be lobbying. I can just spend an entire day deep diving and reading about things that I otherwise wouldn't have time to do in another role at, say, a law firm or something like that.
Well, I'd love to get a little more into your actual role. I guess I'm sure that plenty of our listeners don't even know what a policy counsel is, but you are
a senior policy counsel.
Yeah, exactly. You're the senior policy counsel.
There are people who are junior to me, but I don't really supervise them. It's sort of like a hybrid lawyer lobbyist role. We take and synthesize a bunch of input from our member companies on a whole host of issues. So my portfolio generally is, commercial privacy issues, including GDPR, Privacy Shield, cross-border data flows, and then the separate bucket of, law enforcement and national security related privacy issues, so surveillance and intelligence access to data. And we respond to events, sort of on the fly, taking on member feedback about them, and then sort of synthesizing it, adding a sort of user rights bit of flavor to that, and then taking it to regulatory agencies, Congress, and the courts, depending on where the action is, and make sure that our members' views are heard. And so that can mean amicus briefs, before the district court in the San Bernardino encryption case. It can mean, somewhat tedious FTC filings in, the NOMI case, or it can mean, doing Hill briefings or taking meetings on the Hill with staffers who are really interested in the subject matter and, have bosses that want to regulate, but aren't quite sure what that regulation would mean. And so, it's fun. Yeah.
You're saying that your job is basically the hybrid of what everyone hates about DC, lawyers and lobbyists.
Yeah,
living the dream.
There's going to be a comic about me. It's already out. It's called Swamp Thing. So.
Nice. So before we get really dive deeper into your roles and into GDPR and stuff, just give us a real quick and dirty on your background and how you got interested in what you're doing now, and kind of a little bit about where you grew up and where you went to school.
Sure. So I am actually a bit of an oil brat. So I grew up in LA, then Houston, and then the Middle East, where I did high school. And so I have, the internet was my way of sort of connecting with everybody back home, but also sort of with building a community when I lived abroad. And then I went to college in Berkeley, and
Go Bears.
Was sort of Go Bears, exactly. We can do the whole drinking song if you want. I know it.
You guys should both do it in sync right now, immediately.
I will absolutely keep it in. I swear to God, if you start it, just go.
What are you talking about? I don't drink. I never partied in college.
There's no evidence on Facebook to suggest otherwise.
Exactly.
Exactly.
That's my story. I am sticking to it. And so in college, I jumped around a bunch of different majors, but at the time, a lot of the more popular internet communities were really just finding their footing, and so it was a nice time at Berkeley to sort of engage with a whole lot of nerds who eventually went on to help develop these platforms. And so, and not even just the platforms themselves, but sort of the communities behind the platforms. And so this was before Reddit, there was Dig, and I was pretty involved in Dig and
as a user or on the other side of things?
As a user and a little bit on the moderation side, and it was just sort of a nice way. It was a nice entree into the modern terrible place that Reddit and 4chan are. But it was nicer days, and so I don't know. I was just sort of always involved in internet sort of community things, but I didn't have an idea that I wanted to eventually become an internet lawyer. I always thought that I was going to end up doing sort of international law related issues because I had lived in the Middle East, and so surely internet. Then I got to law school, and it turns out international law has 3 jobs.
Right.
And,
exactly. You're describing my entire. You're describing my entire school experience. Exactly.
And one of them happens to be taken by the best human rights lawyer, Mal Clooney, and so there's only 2 left, and I didn't feel competing in that market, I guess. But it was also a really good time to sort of be thinking about internet policy, because it was just before the Snowden leaks, and it was and honestly, it was just fortuitous timing. And my law school had a really good program for sort of IP policy, which they run the Creative Commons USA program, which they then turned into sort of an internet policy apparatus. And so I was like, that sounds great. I hear the internet's going to be around for a while. Maybe I should be a lawyer for that. And so I focused at first a little bit more on copyright issues, And then I ended up working for Senator Feinstein for a little while, where we worked on ECPA reform and FISA the last time around.
ECPA reform, eh?
Yeah, exactly. My life is really cyclical in that I have been doing the same thing over every 5 years or so.
Iterating. You're iterating.
Exactly. Yeah, or stagnating. I don't know. But it was like, so I became fairly well versed in FISA and in the warrant for content conversation, and then CCIA, my current organization, hired me on as a fellow to work on a copyright Supreme Court brief, Aereo, which did not go so well for Aereo, but the timing was perfect in that the Snowden leaks happened when I was working at CCIA, and my predecessor, Ross Schulman, who's actually at New America Foundation, Open Technology Institute now, was like, "Hey, we need all hands on deck. You seem to know things about FISA. Join the party." And so it was a lot of parsing what people were saying about PRISM, a lot of the good and bad reporting that was coming out around the Snowden leaks, and then helping our companies navigate that space, prepping our CEO for testimony. And then Ross went off to bigger and better things at a member company, as it happens sometimes. And CCIA invited me to stay on forever, which, I mean, probably has something to do with the fact that I was fairly affordable at the time. But also, was exactly what I wanted to be doing. Working on these issues, I wasn't sure where I wanted to be working on these issues, but I knew I wanted it to be more from a user rights perspective than a pure industry one. And since CCIA had that reputation, I was like, well, I better jump on this opportunity. And so that's what I've been doing since. And it has really never slowed down. I think, post Snowden, the conversation has generally always been about surveillance and less about sort of commercial privacy issues. But I think obviously in the last few months we've seen a shift, and so I have reacquainted myself with a lot of the principles that I learned in my third year information privacy law class, and I don't know that I would ever call myself an expert in anything, but
no one should ever say they're an expert in European law or the intelligence community.
Exactly, yeah.
Still, though, for all of our listeners out there, Berkeley graduate, Senior Policy Counsel, in his 20s, and still has imposter syndrome. So I think it's just all of us have it. It's okay. Everything's going to be all right. Just keep trucking.
So I can't stress enough to my co-hosts and listeners how weirdly excited I am to talk about the General Data Protection Regulation.
Oh, we know, Joe. We know.
In my mind, it's like, if anybody's seen Avengers, it's like Thanos. He's like, it's been coming for a long, long time.
You're totally right.
Reputation.
And hey, spoiler alerts. We're not going to spoil Infinity War for anybody on this.
So I want to talk about GDPR, but I actually want to. I'm just curious. So, what you also mentioned, you've done a lot of work on Privacy Shield, and I assume the predecessor to that, which was the Safe Harbor Agreement. Mm-hmm. A lot of that, I think, the discussion there has been informed by surveillance issues. I mean, the reason the Safe Harbor was struck down was because we have bulk surveillance in the United States. I guess I'm just curious if that has been a bridge for you in trying to sort of blend all of these worlds together, or if
no, that's exactly right.
Okay.
Privacy Shield sort of collapsed within my first year on the job, and I had really only been focusing on that 2014-15 period on surveillance issues around Section 215 of the Patriot Act, because that's what our member companies needed at the time. But it was a really good entree into sort of this world of how does European privacy work compared to the U.S.
Do you understand how European privacy works?
No, I don't, but I'm happy to pretend for the purposes of this podcast. And it was a nice way to sort of like dip my toes in the water, because I could start with like the Safe Harbor privacy principles, and then the shift from those principles and thinking about the recommendations that were being made and what my companies were doing with information. And then sort of developing the new set of Privacy Shield principles, and then watching our companies sort of implement those was a really nice sort of segue into watching our companies struggle to implement a lot of the requirements of GDPR, many of which, to be fair, did exist in European law, just without any real bite behind them. But it was it was actually a very convenient sort of slide into doing sort of more traditional privacy and data protection issues, because Privacy Shield sort of melded both of those. That was a good catch. That's exactly how I view my career. Thank you.
So all right, I guess we could get started. Yeah. What is this general data protection regulation? And you've done work on Privacy Shield. So if you're a company and you're part of the Privacy Shield program, how is that different from, I think, what privacy advocates are suddenly calling for, which is for everybody to just go whole hog on doing everything the GDPR requires? And I realize that's an incredibly loaded question.
Yes. So I think we'll just start with the basics. What is GDPR? So the General Data Protection Regulation is the new, well, not new anymore. It's been completed for about 18 months, but it's going to be effective May 25th of this year. And it's set to replace the existing data protection directive in the EU, which is from 1995, and essentially is designed to sort of elevate and harmonize the way that companies and users think about data and its use in as it pertains to European data subjects. It includes a host of different rights, which are largely already extant in European law, but they now have a whole host of additional sort of a bit more, I guess, stick behind them in terms of sort of the enforcement mechanisms. But they include new and evolving ideas around data subject consent, how data anonymization works, breach notification for privacy harms, single data protection officers for companies, and it's just a whole hog sort of rethinking of how companies, not just internet companies, but all companies, that's the general part, ought to be thinking about how they are controlling and processing data. And I think it's fair to say that it's probably the most impactful or privacy regulation there is. I mean, obviously the U.S. doesn't have a whole lot that compares to it, and so it's big and it's coming, and it's like Thanos.
There's an analogy for the articles in the Soul Stones, but I'm still grasping at it. I'll try to work it in by the end of the show.
Oh, I can see that somewhere. Right to explanation is like maybe the reality stone or something.
Yeah.
Like that.
And what's the right to be forgotten?
Right to
time stone, maybe.
Oh, time stone.
Taking us back to episode 1.
Yeah. It is the time stone then.
I want to know, and as someone who's kind of trying to still get into this field and still learning a lot, from the, you said you read a lot of sources on Twitter and stuff, and and you just see all these on social media and in different areas, you see all these GDPR is coming. Are you ready? What, I just want to know, what are the tech companies going through right now? And are they freaking out? Are they right to freak out? What's going to happen?
So I think there are companies that are freaking out. I don't think that they're generally the tech companies you would think of, because most of the existing, the larger social media platforms and email providers and consumer-facing entities have long, because they have European audiences, have long had to comply with safe harbor and privacy shield principles, have had to be compliant with the directive since '95, and even before that, had to think, because many of them are subject to FTC consent decrees, about having privacy programs in place that sort of and integrating privacy into their design process. I think the people who are really surprised are the folks who handle data but don't realize they're handling data. They don't think of themselves as data companies, right? If you're a pizza delivery shop, you take personal data in because you need to know where to send that pizza. You have to think about, am I a controller now? Okay. So the one thing I will say that is somewhat positive in my experience about the General Data Protection Regulation is that it's general. And this is sort of like when, you're asked to compliment somebody and you say, well, he's tall.
I was going to say the one thing.
Yeah. it's that like there is no like picking winners and losers where, we're going to regulate the ISPs and the internet companies, but not the data brokers. It's everybody who handles data has to be thoughtful about it. That's a good thing. And our companies have used it, I think, as an opportunity to sort of reassess and reinvest in their privacy programs. They've made, I can talk a little bit about how, like what we've been hearing from our companies, beyond you guys all got that slew of privacy policy update notifications.
Oh, every day I've been keeping
exactly.
tally. But no, you should feel free to share inside knowledge with us.
Well, it's not inside knowledge. I'm not going to talk about any specific member company, but I can tell you sort of like what
pseudonymize.
Exactly. I can talk about what the common threads are that they have sort of shared with us, and a lot of it really is sort of redoing how privacy programs, not redoing, but sort of rethinking about what they do with data and why they're doing it. They ask a lot of questions of themselves now that I think maybe they weren't, always asking before. They start with their sort of existing systems and services. They're like, what are our current uses and needs for data? In industry parlance, they're just doing data mapping, but these data maps are enormous now. And it's sort of like, looking at their relational databases and I'm not a engineer, so I probably got that term wrong, but basically looking at all of their data sets and saying, how do we get this data or personal information? Why do we have it? For what purpose do we have it? Do we still need it for that purpose? How's it stored? To the extent we still need it, why do we still need it? Can we articulate that in a clear way to our users? Does the data get processed, which is sort of like, is an operation happening on that data, some sort of technical or algorithmic operation? Why is it getting processed? Do we have a legitimate reason for doing that? Can we articulate that to our users? Does the data move? Does it get transferred? What are the requirements? Or what have we been doing when the data gets, is at rest or is in transit? But what sort of protections are we affording that data? And then they sort of, once they have this map in the set of characteristics for the data that they currently hold, then they evaluate sort of the existing controls and services that they have for their users. What notifications are they currently providing? What sort of, opt-ins or opt-outs or, dashboards are there? And then they have to compare. And now like a lot of this for larger member companies can be done to a certain extent in-house. They have a whole, raft of privacy professionals.
So let me ask,
go ahead.
how still, and this gets to my follow-up question of what you think is unfair with the GDPR, but how easy is it to do all of this? This, to my mind, sounds like you're sort of describing responsible data governance, but there also is a lot of stuff in there.
Exactly.
And also, what happens too if, like you said, these companies who are not aware or don't think of themselves as tech companies or companies that collect data, what happens to them if they find, they end up being non-compliant?
Mm-hmm. So on the first side, I guess I think you asked sort of about, fairness, or it's for some companies, it's not a huge burden. They have these programs and responsible data practices in place. There's some tweaking that has to happen to ensure that they can now afford the right to access or the appropriate, means of portability for that data. But generally speaking, like, there's a certain class of companies that this is not like the end of the world for. I mean, it's expensive for them because they have to still hire outside counsel to ensure that they're doing their due diligence. And but in the end, like, that's sort of a pittance. It's the folks who don't have these, who are smaller companies who have either not really been thinking about themselves as sort of data controllers or processors, or the companies that who know that they have data and use it, but don't really have, like, existing legal teams and privacy teams ready to adapt everything their engineers are doing, because it's all sort of being built on the fly. Those are the folks for whom I think, one, as a percentage of revenue, they're now having to put a little bit more into this sort of, legal and compliance function than they probably wouldn't have as sort of maybe earlier stage startups or mid-sized, not mid-sized tech companies, but, folks without these sort of like general counsel shops. And
well, I guess, on the one hand, it feels a lot from the privacy advocate side that we're taking something that was always, privacy was always put all the way to the end and almost as an afterthought all too frequently. And now it is, again, how Joe was describing it, responsible data usage.
Mm-hmm. No, I think that's fair. Every company sort of has to have its reckoning with how they are handling personal data, and it's better to have it proactively.
I am cutting that. I am clipping that for the show. Every company has to have their reckoning. Yes,
exactly. I mean, and this reckoning happens to be from Europe. I mean, it's better. I think our companies are dealing with GDPR. I think they, in some ways, also recognize that better to be proactive and implement responsible data practices to the extent they haven't before things go sideways. So
it sounds like you're saying GDPR is the standard.
I don't know that it's. I mean, it's causing them to rethink how they're dealing with data, but I don't know that it's necessarily the standard for everywhere and everything. Every company is approaching that their own way. Some companies have committed to doing that. Well, since we're doing GDPR for European users, we may as well just implement it across the board. For some, it's well, maybe not. And for a lot of smaller companies, they're trying to. It's time to sort of make hard decisions. Again, I go to Twitter for some takes, and I think last week at one point there were a few tweets about a company called GDPR Shield.
Yeah, I was going to bring that up.
And all it does is, if you are a small web user or an app developer or something like that, it essentially just blocks all European IPs from accessing your website. And that seems unfair, right? But think about it from the smaller company's perspective. I have 3 engineers and an outside lawyer who I sometimes call to deal with some of my contracts. I don't have the bandwidth to prepare for GDPR. I'm still trying to build a user base in the United States. I'll just cut off European users for the time being until I'm a big enough company to deal with that burden. And that might mean that European users miss out on some newer services for a little while. But yeah, a lot of these companies are going to make tough decisions about where they expand to, where their next markets are, and it turns out that onerous privacy regulation can be a factor in that. We actually did a study on the time from when I think the e-privacy directive was implemented, and not e-privacy directive, the original privacy directive, and then the e-privacy directive from 2003, and sort of looked at relative levels of VC investment in Europe compared to the US and a couple of other baseline states. And obviously it's not perfect because there are different tax structures and investment guidelines, but there is a statistically significant decrease in VC investment in Europe over the period following the implementation of the directive.
So the GDPR literally does kill innovation?
Well, not necessarily. It's
this is the CCIA's official position.
This is just an inference drawn from economic data. We would never suggest causation. We know better than do that.
I am interested in your personal opinion, though. I mean, I feel like I can almost buy the argument. I think that from my side, again, from the privacy advocate side, I think it feels like the complaints to come into compliance are maybe exaggerated, but I can at least buy that argument. What I find less convincing is the idea that this is going to present a serious barrier to new small businesses. I can understand if you're a business that has been operating this way and you've got your budget and then suddenly a new regulation comes down, it can be a huge problem. But, if you're college kid today that you want to start a business tomorrow, and now a year from now, and GDPR is the law of the land in Europe, I mean, it seems like that would just be sort of responsible data use.
Yeah, something you have to deal with. Sure. And it also could lead to, I don't want to, there could be some innovation in a different sense, which is that maybe some of these newer companies will think about different revenue models. I don't know what they are. No one actually has
or
ever
different
figured out.
markets, like
Exactly.
maybe not just Europe, maybe Asia, maybe Africa. I mean,
yeah, they may one choose, hey, well, actually, this market seems to have less stringent data security or data protection requirements. Maybe I'll just launch there instead. But there's also the other option, which is, hey, no, I do want to serve a European audience. I can't exactly do the same level of monetization based on delivering targeted ads or something.
Yeah,
like that.
So let's let's point on that, because I liked talking about Twitter hot takes. I think that one of the takes that was circulating last week, I think it might have been Whitney Merrill who had said that, or Matthew Green, I don't know, but someone had said that if for all these companies that are saying that they're shuttering because of the GDPR, well, that's really just a hint to your users that they're selling your data. What is your take on that? Does that feel like an honest or a fair take?
I mean, it's not no takes. Well, some takes are unfair. There are no bad takes.
Wow, clip that. There are no bad takes.
I am going to, yeah, absolutely.
At least about GDPR, but
right. At least about GDPR.
I think users have been told that kind of ought to know to a certain extent, right? Like, you assume the risk, I guess, of
all right,
signing up for a platform, but no, I think that's not. I think that's fair, and maybe that will precipitate new business models. I know our companies are not solely dedicated to the idea of using targeted ads. They are trying to innovate around their business models as well. We just need to figure out one or many that sort of stick as alternatives, and then you'll maybe see some additional innovation on how privacy protection works as a selling point used as well. That hasn't worked yet, right? Like, we've seen a whole bunch of these ephemeral social networks that, they're ephemeral in two senses. One, that your data is ephemeral with them, and two, they're ephemeral in that they disappear within months, right? Because they can't make any money or generate any traction with users.
Speaking as someone who works as a privacy advocate, and also I think we're coming at this in the wake of Cambridge Analytica and the Facebook controversy. I
actually hadn't heard about that. Could you?
Yeah. Let's give everybody an overview of what happened there. Well, so what I think is really I still want to ask you what your favorite article in the GDPR is, because I feel like that needs to be like a test for folks anymore. But I think what's really fascinating about the GDPR is it's driving U.S. conversations in a way that I hadn't anticipated. Obviously companies are thinking about it, but congressmen are like, there's this European thing, and even the press seems to have finally clued on that privacy matters in Europe, and so what does that mean over here? So as someone who is a lobbyist in the swamp, what's your take on privacy legislation in the United States and how the GDPR is informing that?
I think up until this point, it hasn't really. There are a lot of staffers now sort of asking, like, what is GDPR? And I'm happy to provide them with information about that, unbiased and unfiltered. But I do think that the terms in GDPR are sort of like filtering. They're like, oh, data portability. What does that mean? Could we think about that in
what does that mean?
Well, it could mean a lot of things. It's different than data access. It means being able to take and again, ownership of data is still sort of fraught, but it is taking data that you have provided to a service with you to another service in a way that is, this is now personal and not like professional. Like, it ought to be sort of machine readable and accessible to that secondary or third service, so that you can sort of move between. A lot of companies always like to say on the internet, competition is a click away, and this the idea is sort of enable that competition being a click away. How it's done and how it's mandated are all sort of nuances that European regulators are still thinking about, and certainly that American Hill staffers have very, very recently started to noodle about. But it is, it's part of this conversation. Like, so these are the ideas that people are now asking, like, okay, does GDPR include right to be forgotten? That's sort of like, would we be able to implement that in the United States? And I'm like, well, hell no.
All right, we can get rid of that article. Don't have to worry about that
exactly.
one.
But there are ideas around sort of how do you import some of maybe not the exact protections, but sort of the principles like, hey, you need to have a user-centric model of thinking about how you're handling data as a company. I don't know if there's any way to write legislation that mandates that, but it's starting to sort of inform how legislative principles and staffers are thinking about it. So 2 weeks ago, I was all over the Hill talking to because there was just a flurry of following some testimony from Facebook, a flurry of legislation sort of coming out, Consent Act, another bill with a less interesting acronym from Senators Klobuchar and
Kennedy. It's
Kennedy.
bipartisan.
That's right. Yes, that's right. Bipartisan. And in the Browser Act from last year, zombified a little bit because Marsha Blackburn is running for re-election and or running for a Senate seat. But all these bills sort of came up, and they were all thinking about data in the same sort of or not data, but about how to regulate in the same sort of, well, these companies have relationship with users, and so we ought to regulate them for their relationship with users. That's initially intuitive, right? I sign up for a website. They have a privacy policy. I agree to their terms. So that's the hook for how we can regulate in privacy here. One thing that GDPR does, I don't know if this is the right way to do it, but it again, it's general, right? So it catches all those companies that are doing things with data that don't necessarily have a relationship with the user, and who in many senses may be bad actors. Or just the invisible actors, and so we don't know exactly what they're doing, or users don't know exactly what they're doing, but they just know that maybe it makes them feel icky, right? So there are some good things about GDPR, which is that it doesn't pick winners and losers, and that is one thing that we've been trying to articulate, I think, a little bit on the Hill, which is that you don't want to be writing knee-jerk bills that really only have this sort of myopic view of how data is collected and used online. Really, the sort of direct user to business relationship is really a small sliver of how that happens. And you want to be thoughtful about capturing everybody in the ecosystem. So that, because a lot of the companies also have a whole host of different, some of them are user business to business, some of them are user to user, some of them do all of the above, and so you don't want to just regulate a particular part of a company. You want to make them be thoughtful about these issues as a whole entity. And I think the companies would prefer that too, because they don't want to have to answer 15 different or set up 15 different systems for their different business entity or business services or user services. And so that's one aspect of the conversation that GDPR has sort of started to shift, I hope, to a more sort of comprehensive look about the ecosystem. Whether the solutions from GDPR are the ones you need to implement, that's a separate that's the next step of the conversation. And I think you can guess where my position is on that. But I think on the front end, it is a good conversation to have. So yeah, GDPR is influencing what's going on the Hill. The Europeans are coming.
So one of the things that I'm always struggling with as someone who's interested in privacy is the notion that a lot of this is underlined, and the GDPR does this too, with notions of consent, which devolves into notice and choice, which I don't think works. I guess I as an advocate, I wish we could come up with hard and fast bright line rules.
Do you have a solution to that? Because
well, my solution, and I'd love your reaction to this, and I don't, again, not totally sure how you legislate this, and this tends to be the thing that I think privacy folks see as a slippery slope. But one thing that I don't think we talk a lot about, certainly on the Hill or certainly with legislators, is the GDPR's notion of legitimate interest. I don't know if you have any take on that. I also realize legitimate interest is it's uniquely European because it's balancing fundamental rights. But
I have used the word in meetings with staffers because they don't know what it is, and so
it's like a new buzzword.
Exactly. Because a lot of these bills again are sort of designed around notice and consent, and and just really, deciding whether you want to have an opt-in or an opt-out for a particular type of data. That's like what it all boils down to. And that's not really innovating in sort of the privacy control space. And so, in terms of legitimate interest, there is still I think a lot of confusion around it. I'm not sure I totally understand it myself. I very much doubt that all of my companies do as well. Legitimate interest is essentially a sort of a balancing between whether the company's interest in processing that data, either for service necessity or something like that, it outweighs the fundamental right protection to the user. And so it's just sort of like a cost-benefit analysis. But there isn't really like a set of examples where this is a legitimate interest and that's not a legitimate. Well, there's like one really facile example that I've seen a lot, which is the sort of pizza delivery person. You have a legitimate interest in collecting and processing address data to deliver your pizza service. And so you wouldn't have to go to consent for that because it's sort of part and parcel with your delivery, what you're doing. But there's a lot of our companies are defaulting still to consent because it's unclear how, direct marketing, there is an explicit allowance for using legitimate interest to allow for that in GDPR, so long as you can make the balancing arguments again. But for third-party marketing and in the traditional and the modern cross-device tracking ad space, it's much more difficult. And so it's a whole lot easier to just sort of default to consent. And so this is not a failure of imagination on the GDPR's part, because consent is just sort of how everybody, has operated in this space. I mean, it was actually they were imaginative to think of this sort of legitimate interest mechanism. It's just because there's an opportunity to stick to what for the time being, everyone is doing that. And maybe if they were really daring, they would have not involved consent at all. They would have just been like, what, you can only use legitimate interest, figure it out for X types of services, and they would have been more detailed about which ones those were. But they haven't been yet. So companies are still sort of defaulting to the 7-digit number they're used to, or whatever.
Hey, so what is your favorite article in the GDPR?
Article 3, extraterritoriality.
Ooh.
Because it's
everyone
it's
grab
the one
your pocket
makes,
GDPR books.
It's the one that makes the GDPR the sort of behemoth that it is. It makes you don't just have to appreciate the GDPR's requirements for European data in the EU anymore, or it's extraterritorial. You have to operate internationally. And a really interesting question that this raises is, well, if we're treating European data subject information the same way anywhere, why do we need Privacy Shield or BCR or binding corporate rules or standard contractual clauses or any of these mechanisms that are sort of adequacy based, which are also included within the context of GDPR, within the terms of GDPR? Why do they exist? The entire point of them is to ensure that there's essentially equivalent protection or adequate protection for European personal information around the world in countries where it might be seen as, or where the laws might be seen as lacking. Looking at you, the United States. But they have to do that now under Article 3. So what's the point of signing up for Privacy Shield? And so this is a question that I know a lot of people are probably asking the DPAs, and there is going to be in June, I think, an additional guidance from the DPAs about what constitutes a data transfer and for what purposes you need to have these. Hopefully, they will say what purposes you need to have these adequacy mechanisms, as opposed to just treating European data as you would in Europe elsewhere.
Sounds like exciting summer reading.
It is. It's going to be really fun. Article 3 is what makes GDPR. I mean, I guess I don't remember what the article is for the. And I guess, Pinal, you did ask about this, what happens if you're bad?
Yeah.
And I don't remember what the article is for the fines, but it's either 10 million euros or there are thresholds obviously for different types of violations, but at the high end and repeated violations obviously, it could go, it's whichever the greater is of 10 million euros and 4% of your company's global turnover. Not even your turnover in Europe, we're GDPR, we're global, so Article 3 makes us, reach everywhere. So we're going to make sure that we can reach into your coffers everywhere. That's a big number. And I mean, I understand why, it makes sense to have a stick in this instance. I just hope that it's the DPAs, apply it with discretion, sort of, if people are they have good privacy and data protection programs in place, but they're slip up or something like that, or, and they come in and they have this conversation with the DPAs and they're like, oh, well, we understand it. Thank you for flagging that, or, we're going to rectify it. They won't go straight to the like the SMU death penalty fine or something like that,
Well, this has been a lot of fun.
Yeah.
I know that Joe and I are going to be in RightsCon next week. So actually, listeners, I think that by the time you're hearing this, it will have been last week. Bijan, are you going to be up in Toronto with RightsCon as well?
I will. I will be at my first RightsCon. I'm like many people, overwhelmed by the sort of like breadth and depth. I'm going as like a privacy lawyer, and like I keep forgetting that privacy is just like one of like the things that people consider rights, like
there are other fundamental rights out there.
Well, I mean, I can't even commit to saying that privacy is a fundamental right, because it's that's in Europe. That's
right.
That is not how.
Yeah, we didn't get into that topic.
Yeah,
I think using that scheduling app, I got to about 12:30 p.m. on the first day, and I only had about 13 overlapping events and panels that I need to go to. So. Yeah, it should be fun. We should, by the way, divide and conquer and get some cliff notes from each other.
No, I think that's definitely the right approach. And the side conversations at these events are always much more fun than the ones that you're having, and plus they tend to have free booze associated with them. So
I was going to say beverages. Beverages are usually involved outside of the conference rooms.
Can our listeners follow you on Twitter or any other social media? Anything you'd like to plug? Things that are going on in your life?
Yeah, so I'm on Twitter at Bijan M, so that's at BIJANM. And you should also read CCIA's Project Disco blog, which is where we talk about, we just relaunched the website. It's where we talk about sort of interesting issues in disruptive competition and in tech policy generally that sort of impact smaller companies and startups, and sort of affect how they can emerge in.
And I was gonna say, you also mentioned that you get a lot of your information from Twitter. So what are some of the handles that we can follow to stay up to date?
For really interesting thinking about the internet ecosystem and whether how its benefits or harms for users, Kevin Bankston is always a really good thinker about these issues.
He's going to be at RightsCon talking about speculative fiction while we're talking about technical, boring things.
Once you're Kevin, and you've already done the privacy rights advocate side of things, and you've done the surveillance advocate side of things,
is that
you
the
can just
making
sort of
tech policy with science fiction? Was that the panel? Because I saw that one. That looks incredible.
Yeah. You can talk about whatever, and you can have panels where the producer of Sneakers comes and risks for an hour and a half, and and everyone will watch it. Unlike panels about GDPR, perhaps.
I expect packed rooms.
Like podcasts. Exactly. Amy Stepanovich from Access Now, one of the hosts of RightsCon, is again another sort of. She is again sort of a user rights activist, but also sort of thinks about how the user rights and privacy policy ecosystem is populated. Like, who are the people doing these things? Is there diversity? Does that reflect the people who who activists are supposed to be representing? And so she's really thoughtful about those issues. And then if you're interested in talking in following sort of the surveillance conversation, but want a sort of a different angle on it, and someone who's really thoughtful about issues that pertain to Russia, Susan Hennessy from who's at Lawfare and is a former NSA attorney, is really smart, and I'm always at odds with her, but she makes me think about why I think the things that I do about surveillance and about the intelligence community's role in our society. So
awesome.
Those are my 3 plugs.
That's helpful.
All right. Bijan, thanks so much for joining us.
All right, thanks for having me.
Thanks.
This has been an episode of Tech Policy Grind, a podcast from the Internet Law and Policy Foundry. We're a collection of early career professionals paving the way in the tech policy world, and we really hope you enjoyed the show. If you like what you just heard, it would be a huge help and mean a lot to us if you could head over to iTunes and leave a rating and a review. If you don't have iTunes, maybe just share the show with a friend. You can follow us on Twitter at Tech Policy Grind and keep your ears peeled for new episodes twice a month on alternating Mondays. We want to thank Ali Sternberg for producing the intro and outro music for the show, and thank you all for listening. So, until next time, thanks.